Live from SABC headquarters in Auckland Park, Johannesburg. Welcome to this week's Friday edition of the Watchdog. My name is Vuyo Mvoko, and on the show tonight, how Acting Chief Justice Raymond Zondo's interview turned into an appraisal of his state capture inquiry. Find out what legislators and the country's lawyers think of the work he has done. Still on what came out of today's Judicial Services Commission interviews for the post of Chief Justice. Did Justice Minister Ronald Lamola overstep his boundaries by asking the Acting Chief Justice to allow Gauteng Judge President Dunstan Lambo or to be an acting judge in the Constitutional Court? That's a question being raised today following revelations that the minister had actually asked the Acting Chief Justice to do so. And Public Protector Busisiwe Mkhwebane's impeachment proceedings can now go ahead. This after the Constitutional Court today ruled that she can now be allowed legal representation when the hearings commence. And if you want to know why Julius Malema, what motivated him to cut what was once that big stomach of his, well, that too was revealed at the JSE interviews today. All that and more coming up in tonight's episode of The Watchdog, which starts right now.
The Public Protector welcomes the Constitutional Court's dismissal of the appeal lodged by the Speaker of the National Assembly and the Democratic Alliance against the judgment of the Western Cape High Court, which affirmed the right of heads of Chapter 9 institutions to be represented by a legal representative of their choice in the event of impeachment proceedings to ensure fairness and compliance with the Constitution. The Public Protector is studying the rest of the judgment and will issue a statement on the way forward in due course. Opa Sakhalwe, Public Protector spokesperson.
Opa Sakhalwe there with the reaction from the Public Protector following, of course, that Constitutional Court ruling that the National Assembly's impeachment proceedings can now, against Public Protector Busisiwe Mkhwebane, can now proceed now that she has been allowed legal representation. Now, to make sense of it all, to break it down, for us, let's welcome Lawson Naidu from the Executive Director of CASEC, the Council for the Advancement of the South African Constitution. Lawson, good evening. Thanks very much for your time this evening. Well, perhaps we can start with what this ruling actually means for that process, which, started, but of course was bogged down on this matter of whether she should be allowed legal representation.
Yeah. Thank you, Vuyo. I think we must start, with going back to 2019, which is when the National Assembly passed rules, adopted rules to give effect to the impeachment process in Section 194 of the Constitution as regards the heads of Chapter 9 institutions. Shortly thereafter, February of 2020, the Public Protector, the Cape High Court, sought to have those rules declared unconstitutional and invalid and have them set aside. And that is the saga that 2 years later has now finally been resolved by the Constitutional Court. But it's worth reminding ourselves of what happened in the High Court. The Public Protector brought that application on firstly to interdict Parliament from proceeding with its process, the urgent application that failed. On the substantive application, she challenged the rules on at least 12 grounds. 10 of them were unsuccessful, and she succeeded on the basis that that she should have a right to full legal representation during the parliamentary process, and secondly, that it was unconstitutional and an infringement of the separation of powers for a judge, albeit a retired judge, to serve as part of the independent panel that makes a prima facie assessment of the complaint against the head of the Chapter 9 institution. So what the Constitutional Court decided today was that insofar as the issue of legal representation is concerned, that the public protector should be entitled to have full legal representation during the committee process that is yet to commence. And they said that that is necessary to ensure that there is procedural fairness in that impeachment process. And the fact that the public protector may be legally trained is no bar to having legal representation, because other heads of Chapter 9 institutions may not have such legal qualifications. And in any event, it is only proper that she should have that. So on that ground, she succeeded, and the parliamentary process can now proceed. On the other ground of where she challenged the constitutionality of the involvement of Justice Blessing Kabinde as part of the independent panel, the court ruled against the public protector on that regard and in favor of Parliament and the DA, who were the other applicants in the case. CASAC was an amicus together with Corruption Watch and made useful contributions which were acknowledged by the court in its unanimous judgment today. So what this means is that the process that Parliament has conducted up until now is valid, and that the committee that is established under Section 194 of the Constitution can now commence with its work of the substantive investigation into the complaint that has been laid against Advocate Mkhwebane.
And on that last point, it means, in a nutshell, that the process won't have to start again from scratch. What has happened has happened. Yes, Russell.
That's absolutely correct. And in fact, the court was at pains to point out in its judgment today that the reason that they heard this case as a matter of urgency and accepted direct access to the Constitutional Court from the High Court was because of the urgency and the fact that these issues need to be resolved and resolved speedily. And the thread that flows through the judgment is the issue of public accountability, and that there need to be processes. Parliament has put in place those processes, and it's quite clear that Advocate Mkhwebane's legal strategy has been designed to try and delay the process so that she can complete her term of office before the impeachment process can be concluded.
And I'm going to come to that point in a second, but still on what has been done up until now, beyond the coming up with rules for this process and adopting them, what else has actually happened?
Well, so the rules were adopted. Parliament established an independent panel, which is part of the 17-step process that Parliament needs to follow in an impeachment process with regards to the head of a Chapter 9. That panel was established, but only really got underway because of delays due to COVID in the latter part of 2020, and submitted its report to the Speaker, I think, in February last year, 2021. That report was tabled before the National Assembly, and the Assembly passed a resolution that it would institute a committee to go into the next phase of Parliament's investigation, which is for a multi-party committee to be established, and for that committee to hear evidence from the public protector, from the complainant, and to question witnesses and the like. And that's the process that has been stalled as a result of these ongoing legal proceedings, but it can now commence. And as Parliament begins to reconvene at the start of this year, that committee can now get underway with its work.
And realistically, I mean, how soon do you think this process can restart?
Well, it shouldn't take long for it to start, at least, because the members of the committee have been identified. The committee, I think, had an initial meeting to elect a chairperson and so on. So the committee, I think, has also discussed how it's going to approach the task at hand, and it will be able to get underway, subject to parliamentary scheduling and for making time for that committee to meet. But I think it's quite clear, as I say, from the judgment of the Constitutional Court today, that this is a matter that needs to be treated as a high priority. This is a very senior office that is designed to hold others accountable, and that office itself must be accountable. And therefore, Parliament should really prioritize this and ensure that the work of the committee gets underway as quickly as possible.
From what you know from, interactions, conversations with some of the legislators, is there still appetite for it, for this whole thing?
No, look, I mean, whether there's appetite or not, it's the responsibility of the National Assembly to do this because, again, the judgment today points out that the heads of Chapter 9 institutions are accountable to the National Assembly. The National Assembly has now put in place rules for that impeachment process. The Constitution had already made provision for impeachment on the grounds of incapacity and misconduct. And all that the rules of Parliament have now established is the exact process that needs to be followed. So I think, this is something that, and certainly the fact that the Speaker has continued to challenge these issues in court and was partially successful today, means that I think the Speaker is certainly determined that this matter must proceed, albeit that we have a new Speaker now. But I think the institution of Parliament needs to take its oversight responsibility seriously. And if there is a valid complaint, which there is, which an independent panel has said there's a prima facie case for the Public Protector to answer, then it's only appropriate for Parliament to see that process through to its logical conclusion.
The fact, how much of a factor is the fact that she doesn't have a great deal of time left before her term expires? Is that going to be?
Well, I mean, I think the strategy of the Public Protector from the start in this, when these complaints were lodged, was to try and run the clock down, as I said, in order to try and evade accountability. And I think, there's another aspect of today's judgment that's interesting for you, which is that there was a cross-appeal by the Public Protector on some of the grounds in which he failed in the Cape High Court. And, whilst it was probably not entirely necessary for the Constitutional Court to deal with those because there were procedural flaws in the manner in which the Public Protector raised those issues in the cross-appeal, it decided to address them purely to avoid, I think, providing her with the opportunity of going back to the Supreme Court of Appeal and seeking to raise those issues there. That would have delayed the process even further. So I think there's she's got until October next year, 2023, to be in office. But I think, even if she is, if this process concludes a day before that happens, I think the process of ensuring accountability of public officials is an incredibly important one. So I would be less concerned about the timing aspect of it, but focus on the principle that accountability needs to be paramount.
Perhaps just to complete the picture, you may want to enlighten us on the other 10 grounds that she objected to or on something.
I mean, I can't recall them all.
Not all of them, just
But, there were issues of Parliament acting beyond its powers that in defining what incapacity and misconduct mean, that the National Assembly were effectively rewriting the Constitution, and the court disagreed, saying no, that the Constitution says incapacity and misconduct, and what the rules provide is some amplification of that. So they already exist in the Constitution. The Public Protector, for example, said that the rules should not apply retrospectively. In other words, that if they were adopted in December 2019, they could not be applicable to any conduct or misconduct that occurred before that time. And again, the court dismissed that aspect of of her cross appeal. Parliament had acted beyond its powers, that the Speaker was biased and had an agenda to go after her. And the court again said the Speaker is an independent person, that she is required to execute her constitutional responsibilities, which is what she has done. And then another point in relation to the appointment of a judge to sit on the panel is that judge is selected by the Speaker in consultation with the Chief Justice. So the Chief Justice has the ultimate say in terms of who that judge is that is going to sit. And the court said, well, the judge's appointment is for a limited period. The rules say 30 days for the panel to do its work. In this case, they asked for an extension, which was granted because of COVID and the like. So those were some of the grounds that the additional grounds that the public protector had sought to raise as objections to the rules, but failed, as I say, on all of those grounds, except for the one, which I think is one that makes a lot of sense, is that she should be entitled full legal representation during the committee hearings.
Mm-hmm. I have to thank you, Lawson, but before I let you go, I'm going to spring something onto you. It's a story I'm doing, or one of the stories I'm doing next. From the bits and pieces I saw, it occurred to me that in many ways, the Judicial Services commissioners kind of used, perhaps not consciously so, but used that interview, Judge Zondo's interview today, to essentially do an appraisal of his work as the chairperson of the State Capture Commission. And one of the things that came out very strongly was how he treated Arthur Fraser, the former intelligence chief, given the allegations, the host of allegations that were leveled against many people within the agency, the things that went wrong there. And of course, the acting Chief Justice did sort of offer some explanations, but you could tell from the group of people who raised this particular issue, a lot of them thinking that Justice Zondo perhaps mishandled that whole thing, and it's one of the things that will leave a bit of an aftertaste. He could have done this thing differently. But there were other people who were open about the fact that they felt he actually did a sterling job, and how he handled the Arthur Fraser matter was the best way, or the best he could have done, or it shouldn't matter that much. Your thoughts?
Well, firstly, let me start by saying I didn't actually watch that part of the interview, but let me just perhaps offer these thoughts. These interviews are not an opportunity for commissioners to ambush candidates that appear before them. Mm-hmm. And as I think was made clear yesterday, if issues of this nature are going to be raised by commissioners, then they need to forewarn the candidates so that they can prepare adequately to respond to those questions. We had the scenario yesterday with President Dunstan and Lambo, and the allegations of sexual misconduct against him, which ultimately Deputy Judge President of the SCA, Petse, ruled them to be out of order and to be expunged from the record. Similarly, I think it would only to be fair to Justice Zondo for him to be forewarned about these issues. But also, these interviews are not an opportunity to interrogate the workings of the State Capture Commission. We haven't had the third part of the report from the Commission. We've no idea what the Commission and Justice Zondo are going to say in respect of Mr. Arthur Fraser. So it's really improper at this point for commissioners to be questioning a process that is still ongoing, because we haven't had the concluding part of the report. So once again, I don't think those questions are appropriate, and I don't think they should have been asked.
In fact, there's no better person to ask about this than you, because you've taken an active interest in how the JSC is conducting these interviews, and you've underscored the need for perhaps a relook, of the rules of engagement, because sometimes I think there was another instance, for example, where the acting a chairperson took issue with Commissioner Julius Malema about his tone, of voice, which was a bit strange in so many respects. But last one for me, something that came up again late this afternoon, where it transpired that Justice Minister Lamola had actually written to the acting Chief Justice asking him to give Gauteng Judge President Dunstan Lambo an opportunity to be an acting judge in the Constitutional Court. The inference that was being made, it would seem, although they didn't, the people who raised that didn't say so categorically, was that he was being given an opportunity so as to enhance his chances, you know, in these interviews. You know, and of course, I mean, the Justice Minister came, said there was nothing untoward, but then Commissioner Malema saying, no, but isn't there something odd, or to that effect, you know, about a minister writing to you, asking you to give a judge an opportunity to act in the Constitutional Court. And the acting Chief Justice said, well, you know, it's not usual, but I handled it in the best way that I could. And the last I heard of this, the minister was then going to make available or had offered to make available his letter to the acting Chief Justice, and a request was made for the Chief Justice's response to also be made available. Just on the basis of what I've just told you, that does it you know, sort of say anything to you?
Well, look, I mean, I think the first point is that, you know, Judge President Lambo is a seasoned jurist. He's been the head of the Gauteng division for 12 years, I think, now, almost 12 years. He's a highly experienced judge who has not served in an acting capacity on the Constitutional Court. He did serve a stint on the Supreme Court of Appeal before he became Judge President. But you know, he hasn't started that stint as yet as an acting judge, as far as I'm aware. But in any event, Vuyo, the Constitution is very clear in terms of the process that is to be followed in respect of making appointments of acting judges. And the Constitution gives that power and authority to the President. But it's important to also listen to what Section 175(1) of the Constitution says. It then says that the appointment must be made on the recommendation of basically the Minister of Justice, acting with the concurrence of the Chief Justice. They then confer, agree, and make a recommendation to the President, who then makes the appointment. So there would appear to be nothing untoward in the Minister of Justice having a conversation with the acting Chief Justice about who might be appointed as an acting judge in the Constitutional Court for this coming term that is just getting underway.
Losa Naidu, thanks very much for your time and insights this evening, and thank you also for indulging me on the other stuff this interview was not about. Thank you so much. Losa Naidu, who heads the CASAC, the Council for the Advancement of the South African Constitution. And we're going to get into the issues I've just raised with him at the end of that interview in a moment, and that's just after this short ad break. Don't go away. Welcome back. Now, today, Acting Chief Justice Raymond Zondo's interview turned into an appraisal of his state capture inquiry issues. Well, the legislators raising various issues around that, and the issue of former intelligence chief Arthur Fraser, the fact that he did not or was never given, whichever way you look at it, an opportunity to come before the State Capture Commission was raised sharply by the legislators who form part of the JSC, as well as the lawyers who are also a part of those interviews. Listen to Julius Malema, who is a commissioner, asking about why and telling the acting Chief Justice why he thought Arthur Fraser should have been called and asked to appear before the state capture inquiry. Take a listen.
He says he's implicated in a 9 billion, and you say there's a different figure. Surely the commission that is investigating corruption can't miss to compel a person implicated in a 9 billion scandal from state security where there is slush fund and some of which is not even accounted for. This would have been an opportune moment for the commission to expose the rot that has constituted some of the activities in that institution. So I hear that, but my problem is that you still don't call him on your own to come and account for 9 billion, because I'm telling you 9 billion, that's what he says. He says in his objection, I'm implicated on 9 billion. And I'm shocked I'm not compelled to come and answer on this 9 billion.
Before March, there was no reason to force him to come to the commission, because in June or July 2020, he had come to the commission with his legal team and said he wants to give evidence. He has a lot of evidence, but he wants certain documents from SSA. So he was going to come back, and we had no issues with that. But until March, we didn't know what was happening, but we were clear that he and his counsel were very emphatic that they would come back. He wanted to testify, but he wanted certain documents. And then in March, he applies to me to say, compel SSA and the Minister of State Security to give me these documents that are so important for me to respond to these allegations and to tell you about state capture and corruption in general, I think. So I say, okay, but we are on extra time. When you get them, we will see what can be done. And he never comes back. By the time I could have made any decision to say, okay, he's no longer come back, it would have been about September. It would have been too late. And my view would have been, it's so late, his evidence might not just, well, first of all, he said those documents would help him also to respond to these allegations by these witnesses. So he would probably implicate other people, and then who would want to come, and the commission was required to complete its work. So that was the situation we were faced with.
Well, not everyone was satisfied with that answer. Take a listen to what another commissioner, the Speaker of the National Assembly, had to say on this very same question.
The allegations against Fraser were damning allegations. Don't you think it would have been proper to say the accounting officer at that point, whose allegations against him were really weighing very heavy on everybody, should appear before the commission, should answer for himself or present his side of the story to the commission?
Part of the problem with Mr. Fraser was that he seemed not to want to comply with the rules or processes of the commission. If he wanted to testify, all he needed to do is to apply, and his application would have been decided as many other people had applied and they were decided. He says, I didn't want him to testify because his evidence would disturb the narrative that I wanted to follow. But the best way for him to test that would have been for him to apply for leave to give evidence.
Of course, that was not the end of this particular issue. Several other commissioners went back and forth on this very same question. But this is what Justice Zondo had to say in the end, or to wrap it all up.
You did a wonderful job at the commission, and what is coming out very clear is that there would be a lot of prosecutions emanating out of that particular process. And I'm following the question that Honorable Magwanisha was asking. And the way I see it, I'm quite concerned about the quality of our prosecutors. If you've done such a work and those who are on the wrong side of the law are to be prosecuted, and you don't have strong prosecutors, state law, state advocates and so on, what is going to happen with those cases? If the accused contracts Advocate Madonsela or Advocate Mpofu, it means we are in trouble, and therefore will never come to know the truth or the perpetrators of the alleged acts of corruption, state capture, whatever that is, are not going to be prosecuted, are not going to be answerable for the deeds that they have committed. What is your take on that, and how can that be coordinated with the prosecution to ensure that that area is given the necessary attention?
I have been in touch with the National Director of Public Prosecutions to try and understand what is happening, what is the state of the NPA is insofar as they may be affected by the operations of courts, and there may be delays and backlogs and so on. And in a note that she sent to me, one of the challenges that she mentioned in relation to the NPA was, I think, precisely the point you make, namely that there are certain crimes, and I think he referred to corruption crimes. I don't know if he referred to the State Capture Commission, and said that in certain cases, these cases of corruption require people with certain expertise and experience, and sometimes they don't have those people. I guess what she may have meant is they don't have them in enough numbers, maybe, yeah. But the note said that there are those problems, and it got me thinking to say, so with the mountains of evidence from the Commission, maybe they will be overwhelmed, and it might be difficult. I even thought whether they should not, and maybe they are already doing this, they should not talk to lawyers in private practice, Advocate Mpofu, Advocate Madonsela, and negotiate deals with advocates who have got those skills, that experience, in terms of which those lawyers could charge at a lesser rate than their normal rate, but they could have work over a longer period. So the fact that they would be involved in that work over a longer period would compensate for the lower rates that they would be charging. But they would then get the skills, and I thought that they could say to those lawyers, when you think about the lower rate that we are asking you to charge, remember that it's also your way of contributing to South Africa with a lesser rate of corruption and so on. It's your own contribution to making the country a better country for your children and children's children.
The acting Chief Justice sharing his views on what he thinks can or should happen to the cases that we're expecting to go before courts after he handles the final part of his report at the end of this month. Now, still on what came out of today's Judicial Services Commission interviews for the post of Chief Justice, The question some people are asking tonight is whether Justice Minister Ronald Lamola overstepped his boundaries by asking the acting Chief Justice about a month ago to allow Gauteng Judge President Danson Lambo to be an acting judge in the Constitutional Court. Take a listen to how that particular conversation went.
And I want to confirm most of the things that you have said.
Yes.
But I just want to go to section 175(1) of the Superior Courts Act. And I'm going to read it for the benefit of the
So there's no such thing.
Of the Constitution, I'm sorry.
I was wondering.
Of the Constitution, I'm sorry, Acting Chief Justice. Section 175(1) of the Constitution says, the President may appoint a woman or a man to serve as an acting Deputy Chief Justice or Judge of the Constitutional Court if there is a vacancy in any of those offices, or if the person holding such an office is absent. It continues, the appointment must be made on the recommendation of the cabinet member responsible for the administration of justice, acting with the concurrence of the Chief Justice, and an appointment as an acting Deputy Chief Justice must be made from the ranks of the judges who had been appointed to the Constitutional Court in terms of section 174(4). What is your understanding of this section?
Well, it says the minister makes recommendations to the president with the concurrence of the Chief Justice.
Section 175(2) says the cabinet member responsible for the administration of justice must appoint acting judges to other courts after consulting the senior judge of the court on which the acting judge will serve. And maybe what is your understanding of this one?
Well, you might have to read that one again because I'm not sure if it's relevant for this question.
No, I just want to show the difference.
Yeah, just read it again.
It's not formulated the same way as...
Just read it.
The cabinet member responsible for the administration of justice must appoint acting judges to other courts after consulting the senior judge of the court on which the acting judge will serve.
Well, I guess all you are doing, Minister, is just to highlight what the Constitution says.
Yes.
And argument might arise later as to what it means.
Yes.
Commissioner Malema asked me the question and I clarified whether he was asking whether it was the norm. And not whether it was lawful or not. And I said, no, it's not the norm.
Yeah, I'm still going there, Chief Justice. The point I want to prick you in, as you said, when we had the conversation, you did not clearly remember what we were dealing with.
Yes.
To the best of my collection, what I remember is that you were now requesting a further extension of appointments of the two JPs. I think it was JP Tlaling and JP Japi, if I'm not mistaken.
Not Japi, maybe DJP Madondo?
Yeah, I think DJP Madondo. So I raised the matter to say, there are other JPs. Why don't we also rotate and give them the same opportunity that we have afforded these other JPs? And I think, if I remember, that was the discussion that I raised at the time. If I'm not mistaken.
No, my recollection is different. I received a letter from you. So it was a letter that I received first. That was, as I recall now, saying, in effect, it looks like you at the Concord might not be giving judges president opportunities to act. It may have said, and other senior judges, I can't remember, but certainly judges president, opportunities to act, and that you thought that they should be given opportunities, and you mentioned Judge President Lambo, and you said you think that he has the necessary experience and has contributed to jurisprudence or something like that. And then after I had got that letter, I first phoned you.
Yes.
And we had a discussion. And what I said earlier is what, in effect, I said to you, and I said I'm going to write to you and basically say the same thing. And when I spoke to you over the phone about it, and I told you that we had previously invited Judge President Lambo and he declined, you were understanding. That's my impression, that, okay, then, that was my understanding. But I decided I was going to respond to your letter because it seemed you had a wrong impression about whether we had been giving judges president opportunities. And in my response, I gave a number of JPs that we had given opportunities before, as well as senior judges. I mentioned the chairperson, for example, even though he may not have been a judge, just to show that we had given senior judges opportunities. So that's my recollection of how it happened.
Yeah, maybe when the letters come, they will remind us. But my recollection is that it was prickled by the fact that it is to give other GPs an opportunity. But the letters will help. But I do agree that there was that deliberation. Will you say that is an anomaly as the minister, if I raise an issue to say, but there are other JPs, what is the process and all that? Couldn't we consider them?
Well, I think you are linking it to Commissioner Malema's question. He was simply asking whether it's a norm, and I said it's not a norm, which is obviously different from whether it's lawful or not lawful.
No, is it lawful?
No, I don't want to get involved in that. But what I do know is that it's not normal. It had not happened in my experience, at least.
Advocate Dalimpofu was not going to let it go. Develop the point even further.
You invited Judge President Lambo to act in the Constitutional Court now, and whether it had anything to do with this process. He said something about the president did this and then he didn't finish the sentence. What actually happened?
This is what happened. Some time back, I don't know whether it was 2020, I suspect it may have been 2020. The Chief Justice and I had discussed possible candidates for acting, and we had agreed that we should invite him, that is Judge President Lambo, and the Chief Justice had asked me to make the phone call and talk to him and try and hear whether he would agree. And I made the call, but he, as far as I can recall, he declined. My understanding was that he was not declining on the basis that I'm not available at that stage. Maybe I can be available later. I may have misunderstood him, but my impression was that he had declined. So I reported back to the Chief Justice. So we looked for other people. Then last year, after I went back to court and became acting Chief Justice.
Sorry, Mr. James, I'm really sorry to interrupt. I do understand. He looked uninterested, and then you called him again.
Yeah.
Just one, this part.
This part, that's the one I'm coming to. I got a letter from the minister expressing concern that in the Constitutional Court, it looked like we were not affording judges president opportunities to act in the Concord. I don't know whether he included senior judges in general, but I know that he mentioned judges president.
Specifically,
and he asked me if I can't remember how he put it, but he was asking me that he should be allowed to act in a certain term. I think it was the third term, if I'm not mistaken.
Who's he?
The minister was asking if Judge President Lambo I could consider him to act in the third term, because he was of the view that he is experienced, he has contributed to jurisprudence. At that stage, I said no, because I had already enough people, or maybe not enough, but I finalized acting appointments. But I did say to him, we had asked Judge President Lambo some time before, and he had declined. So it's not as if he had been sidelined. And I also explained, gave him names of a number of judges, president, who had been given opportunities in the Constitutional Court, to say, here is our track record, how we have given judges, president, and other senior judges opportunities. But I said to him, if I recall correctly, because we had identified him before as one of those who are deserving of being given an opportunity, I could consider him at some stage in the future.
Yes.
Which is
thanks. That's enough. Acting President, I know I'm not allowed to follow up on my own question, but just a small question. In the same vein, can you just, and after this I'll go, can you just tell us now the circumstances under which Judge Winterhalter's acting came about? Because the reason I'm asking this is because there is concern that has been expressed that there are judges who were shortlisted, if you remember, and then 2 were selected by the president, and that at least one of those judges had never acted, but he was overlooked, and someone whom the commission had not even shortlisted has been made to act. Can you just clear the air?
Yes.
Who called who this time?
Well, this time it was this body in October when we finished our interviews that expressed the view that I should consider giving the candidates who had not been appointed or whom we had not recommended an opportunity to act. And I gave him an opportunity because that was the view that was expressed by this body.
No, but we said those people who have not had an opportunity to act. I'm just saying in that group that included somebody who had actually, by this body's ranking, had been recommended. So shouldn't that person have been the first person to be considered rather than one who had been, let's say, not appointed? Maybe it didn't cross your mind, but I'm just saying.
No, my recollection is that...
I'm so sorry. The reason I'm asking this is because that person did not put themselves forward again, and I suspect that they might have felt that, well, if I can be overlooked like this, then...
I think that person, if I'm not mistaken, is somebody whose name we put forward to the president. So at the time I made the decision who to invite, we didn't know whether he would be successful with the president or not.
Thanks. Yeah, no, that explains it.
Yeah.
Thank you very much.
Follow up.
I'm sorry, Acting President.
Yeah, follow up also, Acting President.
Thank you, Commissioner Mpofu. Commissioner Malema.
Thank you very much. Is it a norm for a minister to send people to heads of courts to act like it happened in this case where a minister suggests that J.P. Lambo must come and act at the Constitutional Court?
Did you say, is it a norm?
Yeah.
Oh, no, it's not a norm.
It's a first of its own kind.
I don't know if he or any other minister may have done it before, but it's certainly not a norm.
It didn't come as a shock to you that a minister can go all out to suggest someone to come and act, particularly a person who's even nominated for the position of Chief Justice?
Well, I don't think at that time he was nominated. There were nominations, but I did see it as unusual but I acted in the manner in which I did.
Well, many of you will remember Julius Malema with a big belly in years gone by, not the slim, trim Malema you are seeing today. Well, today he did reveal where the new body came from. Take a listen. Okay, well, we don't have that clip. What a pity, but that's where we're going to end the show this evening. To join us again on Monday. Have a good night and a great weekend.